Statement taken
On March 1st, 2007.
2007. How many years is that? Let's do this together. 2008, 2009, 10, 11, 12, 13, 14, 15, 16, 17, wait, 18, 19, 20, 21, 22, 23. How many years is that?
23.
No.
Oh, I'm sorry.
Welcome back to Time Served, the channel that scans the docket so you don't have to. I'm Phil, and here she is, Miss Michigan. Sheldon over here. Mr. Martin in Judge Wagner's courtroom, and utter confusion from another defendant. Then we go to Judge Sean Perkins' courtroom, where he has a mouthful to say to this youngster going 60 miles an hour over the speed limit and was caught previously going 112 miles an hour in a rural area. Then we travel down to the Lone Star State, where Judge Stevens and Judge Boyd are up to their usual amazing selves. And finally, a new fan favorite, the Honorable Judge Rosie Speedlin Gonzalez, runs this alleged abuser through an absolute buzzsaw. The hearing gets a little cut off at the end, but the meat and potatoes is there. Don't forget to hit that like and subscribe, set your notifications to all, and never miss the Daily Docket. Court is now in session. Let's roll, nerds.
I think this iPhone is Shelton Martin again. I don't know what's going on with his stuff either.
Yeah, I got an offer for him, but
Hello?
Okay, Shelton Martin, you're back in the room. We're not sure what's going on. Let me see one more time.
You know what? I think I know what it was. It was that my phone bill is due and I was having a bad connection, but I'm using someone else's hotspot. So it should be better now.
Okay, let me see if I can put you in the breakout room now.
I do.
Sure. Well, I can't do it.
My name is Shelton Lewis Martin.
Do you swear or affirm to tell the complete truth?
Yes, I do.
You may lower your hand. This is ticket number P1446955. The People versus Shelton, Shelton, Martin, Martin, the second. That's correct? The second?
What is this Shelton Martin?
Pardon me?
It's just Shelton Martin.
Oh, sir. Are there two Shelton Martins before you?
No, it's just my father before me, and then it's me.
Right. Well, we still have to show who you are. Okay.
I'm
so
sorry. It's always
all right.
a mix-up. Sorry.
Okay. All right. Well, I'm going to just put something else out here so we make it clear on the record that this is Shelton Martin with a date of birth of May 4th. I'm strike that up. November 17th of 1978. Is that correct?
That is correct.
Is that correct? All right. And the reason I do that, sir, I often have people come in here that are juniors or the seconds or the thirds, and other people come in and say, no, that wasn't me, that was my son. Or so I just want to make this record clear who you are. All right. All right. You have three counts. You have three counts. Count one is a misdemeanor for no insurance. Count two is a civil infraction for disregarding a traffic control device. And count three is a civil infraction for violation of basic speed laws. The people have made an offer that if you were to plead to the disregarding the traffic control device, the violation of basic speed law would be dismissed and the no insurance charge would be dismissed. All right. And that is a civil infraction. That's not a misdemeanor. All right. Did you have an opportunity to speak with the attorney concerning this?
Yes, I did, Your Honor.
And how do you want to proceed today?
I would like to take the offer.
Very well. All right. I already swore you. You understand that that you have a right to challenge these matters, the civil infractions and the misdemeanor. You could have a trial for the misdemeanor. You can have a formal hearing for the civil infractions. They would be conducted simultaneously. It's just the standard of proof is different for each one. For a civil infraction, the standard of proof is preponderance of the evidence. For the misdemeanor, the standard of proof is proof beyond a reasonable doubt. If the For the misdemeanor, if the evidence doesn't rise to a level of proof beyond a reasonable doubt, the verdict must be not guilty. For the civil infractions, if the evidence doesn't rise to a preponderance of the evidence, some people have described that as if you're looking on a continuum, kind of halfway, and then a little more plus that, okay, then that's the preponderance of the evidence, all right? But you have a right to challenge these matters. If you plead responsible today, you give up that right. You understand that?
Yes, I do.
And are you pleading responsible because you are responsible?
Yes, I am, sir.
Right, on the date of May the 4th of 2023, were you driving in the area of East Grand Boulevard and St. Antoine in the city of Detroit?
Yes, I was.
The officer stopped you and cite you or write you a ticket for disregarding a traffic control device. I don't know what that was. That could be a stop sign. It could be a light or some other traffic control devices. Did you disregard a traffic control device, sir?
Yes, I did.
The court will find you guilty of that charge. The other two matters I strike that. This is a civil infraction, so you cannot be found guilty. I find you responsible for that. The other two matters would be dismissed. Your fine for disregarding a traffic control device is $130. $130. That is a civil infraction. It must be paid within 14 days of today's date. Do you understand that?
Yes, I do, Your Honor. I'll have it paid.
You know where to pay?
Yes, 36th District, correct.
Well, that's one way. You can also pay it online. Hold on. You can also pay it online at the 36th District Court website, 36thdistrictcourt.org. You can also pay at one of the kiosks that's located in and around the city. Kind of looks like an ATM machine. You can pay your public utility bills there. You can pay by cash or by card, and they're all over the city. And lastly, yes, you can come into the courthouse and go to a cashier's window.
Well, I'll definitely be really soon to come bring that $130. I'm sorry about wasting your time with this.
No. This is not my job. This is my job, so you're not wasting my time, okay? So this is what I do. This is my profession. All right, but you're all set. Good luck to you. You can sign off. Stay safe.
Okay, thank you. You have a good one.
Someone who just popped up on the screen, I just let you into the courtroom. It says Zoom user on the screen. You have on a blue T-shirt. What is your name?
Michael Moore.
Michael Moore. Hold on one second, Mr. Moore. All right, Mr. Moore, you scheduled for 8:35. Why are you coming in here at 10 o'clock?
So with my phone, I'm not gonna be honest with you. My phone was off.
I hope you're gonna be honest with me. I don't think you should have to tell me that, but all right.
No, my phone was off. I just recently got it turned back on. Like it wasn't working at first.
All right, Mr. Moore, go ahead and mute your microphone. We'll get right back with you.
Okay.
Carol Mack, Your Honor.
Carol Mack. All right, Ms. Mack. You scheduled for trial at 9 o'clock. Why are you coming in here at 10 o'clock?
Yes, Your Honor. I've been on the line with 36th District Court trying to Zoom in. They said I could do it from the website, and I was trying to Zoom in, and it was saying something about a letter you joined, no smoking or something, and it said thank you, but I couldn't get in. I did almost an hour. She told me to call you, Your Honor, and see if I could do it because I told her it was a trial and you needed to see me.
That's correct, ma'am. There's no way we can do your trial if you're a call-in.
Ma'am, do you have the Zoom app?
Yes. Every time I go to the Zoom app, it goes back to that letter.
Okay, well, don't go through the system. If you have the actual app on your phone or your tablet or device, you can just type
but I don't have Wi-Fi. But I don't have Wi-Fi.
Ma'am, you don't have to have internet. If you have a telephone that you can go on, can you?
Do you have an actual? Do you have an actual cell phone?
Yes.
Okay, well, you don't need Wi-Fi. If you have a cell phone, then your cell phone has cell data use unless it's not working. So, do you have an actual working cell phone?
Let me see.
Like right now, can you get on the internet on your cell phone?
Yes, yes.
Okay,
That's what I'm
so
doing.
if you have the Zoom app, all you have to do is when you go through the app, like you go onto the app, just put in the meeting ID number. That's it. Do you need the meeting ID number?
No, but I have that.
Okay.
Wait a minute, just a moment, Pump. Just a moment. No, it say I'm offline. I don't understand that with my phone. I don't understand that.
So you need to make sure you're not connected to the Wi-Fi. What kind of phone do you have? Do you have an Android or do you have an Apple iPhone?
Okay, wait a minute. That probably would have been it. Wait a minute, let me see.
Ms. Mack,
Yes.
do you have children or grandchildren that can help you?
No, I don't.
Okay.
No, it keeps saying I'm offline. I don't understand that. And then I tried it on my other phone and it wouldn't go. That's when I got the letter. I had did everything. We had went through it, everything, and then it just went to that letter.
What letter, ma'am?
It was some letter from 30. It said, this is 36th District Court. You have zoomed in. I tried to screenshot it.
Okay, are you sure you were under the right name? Were you under Judge Wagner?
Yeah, I put in my ID number, and then it said, put in a link. I had did all of that. And he said, a link. This is what it say, hello. It said, hello, welcome to 36.
Miss Mack, listen to me.
Yeah.
What ID number are you putting in? Because it sounds like you logged into somebody's courtroom. It just wasn't the right one. So what ID number do you have?
360-331. It said, hello, welcome to 36th District Court Zoom virtual courtroom. Please make sure your audio is.
I know what it's about. Miss Mack, I know
and it won't let, and that's it. It won't even let me go
Miss
through.
Miss Mack, let her talk. You listen.
Oh, okay. Okay, yes, Your Honor. And my name, and it came to that letter.
Okay, I need you to try
Every time I did it, me and that lady did it. Like I've just been trying pumping for like an hour for real, and it keep going back to this letter.
I know it all.
I picked 3-3. It's judge. I choose courtroom 331.
When the letter pops up, you have to hit the agree button. Hit the agree.
They didn't have an agree, Your Honor. That's how I would have hit it. When I put
can you just put her in a breakout room? I'll talk to her.
We may have to. We may have to have a trial with Miss Mack in person.
Yeah, we'll see if we get it resolved, Judge.
We now call cause number 23-41361, the state of Texas versus John Christopher Adcock. You were Mr. Adcock, present with your attorney, Mr. West, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in some?
Yes, Your
Honor. Let's see what was doing there. So robbery, no. Stakes, you have a acquired burglary of a habitation conviction in 2002 out of Hardin County. After that conviction was final, it says you committed a felony of robbery, not this felony, another one, and you were convicted in 2004 in this criminal district court before I got here. I guess there was Judge. Another judge was here before, Charles Carver, and you were convicted of robbery in that case, and here we have a third felony offense. Well, correct me if I'm wrong, but you're looking really at no less than 25 to life imprisonment, right? As an habitual felon? Are we right about that?
That's correct.
Yes, Your Honor, we talked about this.
I'm talking to you.
Oh, you
Sir,
said,
yes, Mr. Adcock, because it seems like you don't appreciate and understand that every felony offense that's above a state jail felony that you commit from here on puts you in a position of life imprisonment with no less than 25 years. And here the deal is for 4 years in prison, but that's awfully generous. But generosity is not what we're all about. It's fairness and justice. How do you think that's fair? You're looking at a minimum 25. So, I mean, what I worry about are people who want to commit more assaultive offenses, violent offenses, robberies, and a violent crime, and think that they're going to get 10 cents on the dollar for their punishment. The people don't think that's right because you've been to prison twice before, and so you know what it's like. You were supposed to adjust for the better, but here you're committing the same offense, a robbery that you committed almost 20 years ago. You were found guilty. It's like you forgot that that's a crime. Can you convince me that this is a worthy disposition? Because I'm the kind of the caretaker of whether a deal should be presented and accepted, but I know how juries are, and we can try this one pretty quickly, but you get convicted of this and the minimum is 25 years prison. So why should you be awarded rewarded a 4-year sentence rather than something higher, for a crime like this? Do you have any money on your books?
no, sir.
At all?
No, sir.
You don't even have money to pay $34 restitution back to you.
Right now, no, sir.
Were you intoxicated this time? I'm just curious. Were you intoxicated?
Because when I walked out of the business, I mean, they served me in a mixed drink. When I walked
But
out,
I'm asking you, were you intoxicated when you did that? By on drugs or alcohol or both?
they served me a mixed drink.
A mixed drink. Well, you must have ordered that, huh?
Sure.
They don't give those for free in this town. Because if they did, the lawyers would be there first. The prosecutors are looking at me like, no. I know.
A lot of them would be too.
Yeah. I think John is on to you, all of you over there, but nonetheless,
You're right. I think
nonetheless, here's the deal is that, so if you weren't intoxicated, why did you do something with a sober mind like this when you've already gone to prison for a robbery? You know it's wrong. You know it has consequences. Over here, look at me.
Sir, listen. Sir.
I'm just, we're trying to connect here because I don't have to take this deal. I really don't. And I can say, let's go to trial, and it's 25, minimum 25, which kind of, puts you in a bad spot from doing a quarter of 25 is 6 years actual. That's 5 more years of actual time in prison than you would get here. But why, sir? I guess you've been here a year. You've been in jail for a year.
15 months.
Sir?
15 months.
15. Yeah. So you know what the deal is here. If I accept this, you're out.
Hope so.
Well, right now, it's just a big wish.
Well, I think I have to do probably 2 more, or a little more. You have to get 2 years, I think.
Why would that be? You have to serve a minimum of 2 on this? I don't think so. It's water for time. There's not a deadly weapon.
Good point. You're right, yes, because it was a threat, not a actually deadly weapon. You're right. It's a quarter.
Can somebody pay that $34?
Pay when I give the lease.
Well, how do we do? We don't have any authority over you, really. I guess parole, but I mean, it's a pittance to what you put people through, but still, the thing is people are going to ask me. So he's looking at 25 to life, but you agreed to a 4-year sentence, and then he walks out. He didn't even pay what he owed, which was $33.99, like $34 to somebody. Somebody's out some money of someone who's been to prison who's looking at his habitual. That doesn't make any sense to me. That's not fair. It's not just. You're a win-win here, but you're the one committing the crimes, and you're getting the big deals.
Well, I promise you, it never happen again.
Oh, you can imagine. I've never heard that. Everybody says that when they're back. A lot of them come back. So, I mean, talk is cheap. Action is what counts. Your action is now, you're back here for the third time. Well, we got to stand for something, and it's not repeated bad behavior when you know better. I'm not taking the deal until this restitution gets paid.
We get the restitution paid now, we'll consider it.
That's what the state feels like. You've looked at it long enough, you think that this is right.
Based on, yes, Your Honor,
Okay.
well, the law and the
Yeah.
circumstances.
Yeah,
Yes, sir.
that's true.
Because me and Daniel talked
I'll
about
relive it, but this is, I mean, and it's all about the principles that are worth something to all of us. And people can't understand how you can get a sweetheart deal for committing a crime for the third time and not have to pay somebody back. And it's just $34 to the merchant. I'm going to protect them.
I'm sure he's got somebody out there that can give us $34.
I don't know, that's y'all's, but I'm not going to take the deal.
Yeah, I'll talk to him and we'll get that, and maybe we get it on the next plea docket. We can do that.
How long? You maybe reset 1 week?
Like, well, I don't know, but could you have somebody else in a week?
I'd have to write a letter. It takes a week to get.
Do you have the phone number? I can make a phone call. I don't have no phone. Okay. So let 2 weeks then, all right.
2 weeks, reset 2 weeks. Thank you. Next is 23 CR 171. That's you, sir?
Yes, sir.
Here's the other Miller.
And Judge, if you accept this plea deal, he wanted to
Reginald Otis.
right. Says if you accept the plea deal, he wanted to waive the PSI because he had this punishment people here now. If you accept it.
Okay, so we have a robbery with a burglary of a vehicle prior, possession of controlled substance prior, aggravated assault of a peace officer prior, and finally, illegal possession of controlled substance robbery. Let's see what we do. Enter Lowe's. Victim approached the suspect, asked to see the receipt, refused to show, and then threatened the victim. Said that he would beat his ass. You said that? That poor guy? Well, that's terrible. The victim stepped aside for fear of being assaulted by the suspect. Then you got into a vehicle and fled. Did you take the stuff too? Did you take the stuff too?
Yes, sir.
So, but you're looking at 25 to life, right? A minimum of 25 years for all of this?
As a habitual.
That's habitual, right? 25 minimum to life imprisonment, right? Okay, all right. I just want to know where we are on what the potential is
And
Wait,
Mr. Manuel.
it's gonna be on, we gotta pick. Figures to count one, which is.
Yeah, I know, but the indictment is that if he was convicted
Yes, sir.
of what the indictment says, you're looking at 25 to life imprisonment, right?
Yes, sir.
That's a lot. Cap of 15 years. What's the restitution on this? Do you know?
Nothing has been claimed at this point.
It has to be something, though.
I think they got the stuff back.
No, he said he took it, right? You took it.
What was the value over there? Lawn, I would get, he said a lawnmower and a weed eater, so that can't be more than $800. A weed eater and a lawnmower, so that can't.
It's about $800.
That's all be my.
Where'd it go?
Police report, Judge, the total of stolen merchandise was $1,929.96.
It's a high one. What are you, I guess if you add.
Well, I mean,
there were total.
That's a high line.
For a total of 5 different items: a mower, a blower kit, a multi-head edger, something called a medicine cabinet, a spool trimmer. But all 5 of those items add up to under 2,000.
Where'd all those things go, though? I mean, where are they now? Well, get them back. Those people. And then I'll give you some money back on this. I mean, they're not new anymore, but we'll give you some slack on the restitution, but you're gonna have to pay a difference because those were new and they're used now, but they couldn't have been used for long though.
No.
How many times did you use them?
I used 7 times.
You remember that? Wow. And what about the other stuff? Did you use all of it?
The lawnmower, the blower, the weed eater.
You used it all?
Yes.
Yeah, I want that stuff needs to be returned back and, maybe they can make some use of it and make it, sell it as a used item to help. And it depreciates what your total amount of restitution is, because I'm going to expect you to pay that back, but it's 1,900 now. And if you don't pay it back, then your probation can be revoked and then you're going up to 15 years. But those people need to pay back. Well, I want that stuff back too, so they can. But their stuff needs to be returned because you're not entitled to it.
I can give my word. I'll pay it back.
Yeah, well,
I'll return what I can and pay it back.
All right, but you're going to be ordered to do whatever it takes to someone on your behalf to get that stuff back. Do you understand?
Can I say something else?
Yeah.
I just found out 9 days ago that my job had called me to come back. I was working in the plant at the new LNG plant in Golden Land since it being banned. 9 days, they just called me back, so I can pay it back. When it's down the bill. I can pay it back.
You got a lot to lose.
I do. That's my fiance right there, still in the green shirt. Now I'm a 2 stepson, baby on a 6-year-old, sir.
Wait. So what's the point of that?
He's telling you all that because they intend to ask you for probation.
No, I know that.
I piled up.
I know that, but you had those children already.
Yes.
When you committed this crime.
Yes.
Well, that you didn't think about. Don't interrupt me. You didn't reflect on how that would not only affect you, but the family that depends upon you. That was kind of a selfish act.
Yes, sir.
I'm a parent. I can't imagine making a mistake that would cost my children not only shame, but loss of my ability to take care of them. We're all family people, but we follow the rules because people depend upon us to do the right thing. But it's clear when you commit a robbery, but then you got a burglary conviction, illegal possession of controlled substance, aggravated assault on a peace officer, controlled substance, all of these, you got one step in 25 to life in the prison. One part of you is halfway in there. You even have more importance, more of a reason. Because you have so much to lose by a mistake like this. I mean, it's kind of like not only a law, but it's kind of a commandment, right? I mean, you're a religious person, not to throw that in there, but I mean, that's all of law is morally backed. It's part of what we know is right versus wrong. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead? And do you intend to commit a crime again in your life?
No, sir. No, sir. I'm tired. And nothing changes. Nothing changes. I'm tired.
Okay. Here's what I'm going to do, folks. I'm going to ask y'all to, I'm not going to take this deal, but we're going to stand by.
Your Honor, we're going to ask that warrants be recalled and waive any reading of the charges.
I'll enter a not guilty plea on your client's behalf. I'll give your client a $0 bond. And at this time, I don't know why Mr. Oglesby does not have a valid license. You're my daughter's age.
Yeah.
And I've already expressed to him, you've already heard to me how I feel about the 31 plus miles an hour over speed. You know, I lived over there for a couple of years, and right there at Van Dyke and Agnes is where I stayed. That intersection there did not have a stop sign. And I was in my apartment and I heard brakes squealing and a boom. Lady got hit and it threw her all the way across the street. Right there on the corner. The very next year, the same corner, her daughter got killed the same way. And then finally, after her daughter got killed, they put a stop sign there. So that was like, whoa, that was serious. So October 13th. So I say all that to say, you're doing 31 miles an hour up Van Dyke. You know, and you don't even have a driver's license. Let's run his license. He indicates that he didn't know why his license was not valid. No, wait a minute. Yes, please. Wait a minute. It says you were doing 87 miles an hour.
Oh, 87.
Yeah, now he's gonna act like he doesn't know. Right. It's best that you just don't say anything. Because I won't say what I want to say.
Judge, I hope you don't mind if I add something for Mr. Oglesby to consider.
No.
which is the fact that if you are speeding like that, that's an open invitation to get stopped by the police, hassled, not necessarily hassled, but all the inconvenience that goes with it. It's like you're inviting them in to make this all happen, court, tickets, money. It just seems unusual that you would drive that way and ask an officer, come and stop me. I'm being bad. It's much better to just play by the rules, slow down, and not have to go through all this.
Mr. Wazir, you don't even need to say that. He's got 112 miles an hour in Royal Oak.
That's deadly.
Listen, I'm not going to give him an offer. He doesn't deserve it. I'll give him an opportunity to take I was going to dismiss the case because he paid the civil infraction, but I'm not going to do that now. I'm going to give him the opportunity to take a better driver's course. This is the type of person that obviously doesn't belong on driving on roads with us, in my opinion.
Judge, if the report from Royal Oak is accurate and correct, that's deadly. That could end up as a felony attempted murder. You don't have to have a specific target. So that's very dangerous, Mr. Oglesby. You're fortunate that you are in this court and not some other court.
Mr. Oglesby, I put the better driver's course in the chat. That's up to you if you want to take it or not. His offer is going to be a failure to display $240. He has an absolute right to a trial. I'm going to put you in a breakout room, Mr. Wazek, and you can speak to him. He obviously needs some kind of counsel. I don't know if your counsel will help, but he obviously needs some kind of counsel. And let us know what you want to do when you come out, Mr. Oglesby, all right?
Okay. Thank you, Judge.
Right.
Mr. Oglesby, please accept the prompt. Judge, he will comply with the court's suggestion. He has already, for me, looked up the website for the driver improvement class, and he will check his status, driver's license status with the Secretary of State. Is all of that correct, Mr. Oglesby?
Yes, sir.
Thank you, Judge.
Very well. And you know something, that's why I can appreciate Mr. Wazak and Mr. Bachman, because they do, in my opinion, go over and above their duties in speaking with you. And I know Mr. Wazak took that opportunity to not only give you some legal advice, but just some life experience advice. Because and you have to understand that your emergency, however severe it is, should not endanger the rest of the community. Because as Mr. Wazak said, and he's been doing this a whole lot longer than me. You see that 35225 number? Mine is 769334. That's bad. But that tells you that he's got probably 30 more years experience than I do with this. He knows what he's doing, and he's got life experience too. A lot of what we do is principled on that, right? I mean, it is just common sense. So, but to say I had a family emergency, 112 miles an hour. And that's one time. Now, going 87 miles an hour in a 35 mile an hour zone, if I were to believe that one family emergency, I don't believe it now.
If I could say anything, Your Honor, the one up Van Dyke was a family emergency because I stay in Detroit. The one in Royal Oak was me on my way to work, and it was wrong for me to drive the speed that much. So,
But do you see how that falls on deaf ears, sir? I don't believe the family emergency now.
okay.
And it could very well maybe because you already got caught doing 112 miles an hour. And if you got the nerve, it takes a lot of nerve to be going 112 miles an hour for any reason. Then I don't believe that I just believe that this is what you do. That's how Attorney Josh Gordon very well, don't you, Mr. Wazak?
Oh, yes, I do, Judge. Absolutely.
I think Attorney Josh Gordon is one of the more brilliant minds that you'll run across, that I run. And he told me, and I was talking to him about a situation that I was in. And he says, you know what that is? He says, that's what you leave in your wake. That's what you leave in your wake. You understand that, sir? So when you're in a boat and you're on the water and that boat is traveling, you're leaving waves back. And the faster you're going, the bigger the boat, the bigger the waves that you leave back there. So while you coming in doing 87 and a 35, and you saying it's a family emergency, very well could be. But when I look at you and what you leave in your wake, 112, then it falls on deaf ears. All right? So I want you to take the course, sir. I would like you to take the course. It seems like you are in an agreement that you would like to take the course. And I really want you to come back and I want you to, I think it's gonna have a lot of those learning lessons in there about these situations when you get in a car and you're pincing into speed or something like that you'll learn. And we would like to hear what you learn when you come back, all right?
Yeah, and the world's most boringest YouTube feed. Here's Mr. Locus. I'll tell him the case has been dismissed, and then I'll go see if anybody brought in any cookies or anything.
All right, I'm going to need everyone to please whisper. We are going to go on the record. And just one moment, let me pull up what Ms. Abrams has sent me. Here we are. All right, the court is calling 2022 CR 0491, State of Texas versus Jeffrey A. Adames. Could I have parties announced for the record for the state?
Travis Banks from the state of Texas.
Defense?
Jay Moritz, Your Honor, from Mr. Adame.
And are you Mr. Adame?
Yes, ma'am.
Is your last name Adame or Adames?
Adames.
All right. I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Jeffrey A. Adames who was placed on community supervision for the offense of assault, family choking, strangulation on February 23rd, 2022 for a term of 5 years? Is that you?
Yes, ma'am.
State.
Violated condition number 28 on or about the first day of May 2023 in Bexar County, Texas. The defendant Jeffrey A. Adames did then and there fail to comply with the rules, regulations, or instructions of the Lifetime Recovery Substance Abuse Treatment Facility, and that the defendant prematurely departed the program without permission in violation of condition number 28.
All right. And Bashan, he's going on 28.
Yes, Your Honor. Thank you.
To that, how do you plead? True or not true?
True.
State?
And the state would waive and abandon the further allegations.
All right. Did you understand by pleading true to violation of 28, the court could find it true, grant the motion, and sentence you up to 5 years in the prison and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of 28?
Yes, ma'am.
Counsel, any objections to the waivers of the other allegations in the motion?
No, Judge.
All right. Is there a recommendation?
Yes,
The recommendation and the agreement of the parties, should Your Honor choose to accept it, is to deny the motion and alter and amend the defendant's conditions for SATIF with aftercare, and have the defendant complete that drug treatment.
All right, is that the recommendation?
My understanding is that it was held in abeyance if he didn't comply, and that he is agreeable to it and wants that treatment, Judge.
All right, probation?
Yes, Your Honor. The recommendation would be for static with the aftercare, and if he does not want to do that, I recommend revocation.
All right, you'll raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand if you'll state your name for the record.
Jeffrey Allen Adames.
All right, why did you leave Lifetime Recovery?
My father was diagnosed with brain cancer. I had to help because I get disability retirement. So he was going to lose his house. So I decided to, my two brothers weren't working. So I decided to leave so I can use my disability retirement to help him out with his, till he had the surgery. And then when he went to recovery in Universal City, he started the recovery. My brothers got a job, so I was able to leave, and I was working on trying to get some money so I could turn myself in, which I did in the 13th of last month.
Yeah, why don't you pick up the phone and call probation and say, my father has cancer and I need to help him?
I freaked out. I mean, I was just, I was just real distressed. I mean,
No, how old are you?
I'm 50 years old.
No, it's easy to pick up the phone and say, my father has cancer. I need to go help them. And then if probation would have said, no, you can't do that, then you know what would have ended up happening? I would have got an email from probation and they would have sent it to me and said, his father is ill. He would like to go be with his father. And then you know what I would have said? Have him come in and we would have discussed it. And maybe I would have let you take care of issues with your father. You are on probation. Probation is a contract. So even though your attorney, the state and probation is saying SATA, I could still say I'm sending you to prison for 5 years.
I understand.
Do you understand?
Yes, ma'am.
So now what has happened? You're still in the same situation you are. Now you're starting all over. When Lifetime Recovery, you probably would have been finished with it by now. Now, instead, if I follow this agreement, you're going to be in custody and wait for transfer to SATA. All because you don't pick up the phone and call anybody. And Lifetime Recovery and all of these treatment programs are supposed to teach you how to deal with your problems. And dealing with your problems are not supposed to be, I'm not going to follow the rules. I'm going to throw my hands up. What if I had a problem and I said, in the middle of this, I have a problem and I just leave. I don't tell you guys anything. And everybody just sitting around here like, what happened to the judge? What's going on? If someone had called me right now with an emergency, if my mom or somebody would call and say, it's an emergency, we need you back home. You know what I'm going to do? I'm going to say, everyone, excuse me for a moment. I'm going to get on the phone. I'm going to call the powers that be and say, I need a judge. I have to leave. I'm going to tell everybody here, everyone, I'm sorry. I need to leave. I need to get a flight. I need to work on that and go home. I'm not just going to leave. And then everybody's like, what do we do now? And in your case, when you just drop off the face of the earth, you know what the what do we do now is? File a motion to revoke. All right. How much longer did he have in Lifetime Recovery? Will Lifetime Recovery accept him back or no?
Your Honor, that would be something I have to research program.
All right, so this is what I'll do. If you want, I will sentence you to prison for 2 years, or I will send you to SATA. And if Lifetime Recovery will accept you back, then it'll be Lifetime Recovery if they accept him back. If they won't, he'll go to SATA.
And if I may, at this point, I really don't think Lifetime Recovery would be the best option. I
Okay.
think we would need something a little more structured.
All right, so it will be SATA. So you can go to prison for 2 years, or either you can go to SATA. Which would you prefer? All right, I'll deny the motion. Alter and amend conditions.
Yeah.
Is there anything else you need from the court so that I won't see you back up here again with the motion to revoke? Probation, is there anything else he needs? All right, good luck to you.
Thank you.
You're welcome.
Okay, are you okay? No, are you okay?
Ma'am, the defendant without bond at this time, there are allegations that he is violating both of the special conditions of bond, including no contact with the complainant, having ownership, use a firearm, and additional violations, and on top of the violations of these bond conditions. I'd first like to call the complaining witness, Ashley Bullock.
Okay, can we bring Ms. Bullock out, please, from the conferring room?
Yeah.
Thank you.
Okay, Ms. Bullock, can you turn on your camera for us?
Okay. Ms. Bullock, welcome to County Court of Law number 13. Can you hear us?
Yes, Your Honor.
Okay, Ms. Bullock, I do need to swear you in. Please raise your Stateson, the attorney for Mr. Booker, will also have an opportunity to cross-examine you. And I ask that you answer those questions as diligently as you do the state's questions. With that, Ms. Flores, the witness is yours.
Thank you, Your Honor. Ms. Bullock, what is your relationship to the defendant, Justin Booker?
We had dated for a while.
And you are you the complaining witness in the case with the date of offense, May 27th, 2023?
I think so, yes.
You think so? All right. All right. We say complaining witness, in other terms, they'll say is victim. So were you the victim of this alleged offense?
Yes, ma'am.
Thank you. And you're aware that there's currently a no contact order between you and Mr. Booker?
Yes, ma'am.
Now, since this date of offense, May 27th, 2023, has the defendant contacted you?
Yes, ma'am.
Do you recall when he contacted you?
He had sent me some messages on different websites and things. And also phone calls.
Objection. She didn't answer the question narrative.
I'm going to overrule that. You may continue to answer the question, Ms. Bullock.
Yes, we've been in contact since then. Yes, ma'am.
So approximately when did he contact you?
I had received a phone call from him because I guess somebody was texting him from a number and he thought it was me or somebody that I was talking to, like romantic interest.
And what did he say in that phone call?
Objection, hearsay.
Hearsay is allowed in bond hearings, and this is a bond hearing. Overruled. You may continue, Ms. Bullock.
Sorry. Yes, he had just thought that somebody was texting his phone. He thought it was somebody that I was talking to, and so he had threatened to slit my throat.
And did you make a report of that?
I did. Yes, ma'am.
Who did you report that to?
I called 911 and reported that to them. I also reported it to my chain of command.
Thank you, Ms. Bullock. No further questions, Your Honor.
Mr. Stateson, any questions of this witness, Ms. Ashley Bullock?
Just a few, Your Honor.
Okay.
Ms. Bullock, are you aware that Mr. Booker is active duty military?
Yes, sir, I'm aware.
All right. And you understand what the state's motion today is for?
Yes, sir, I do understand what they're motioning. Yes.
The title of their motion is motion to remand.
She's answered the question, Mr. Stateson. You're bordering on badgering the witness. She said she understood what's happening.
Remand is remand without bond.
Are you testifying, Mr. Stateson?
I am asking the question. I didn't get to finish asking it.
She answered that she understood exactly what the motion meant and that she understood what was going on. Next question, Mr. Stateson.
Yes, Judge. The messages were post his arrest for this current charge or prior to his arrest?
Could you repeat?
The messages that you were discussing receiving.
Mm-hmm.
The date. The date of it, is it post his arrest or prior to his arrest?
It was post.
Now, do you have a date certain?
I do not have actually. Yes, I do.
Excuse me, Your Honor. I don't mean to interrupt, but I believe the defendant has left the hearing.
Okay, we're going to stop the hearing. Yes.
Your Honor, just to advise the court, when he logged on earlier, he was redirected by myself regarding making sure that the camera was on his entire face at all times. While we were waiting for the court to join us, he started moving around again. So he was placed in a breakout room with defense as a courtesy to redirect him. The camera now, it was only showing half of his face.
Okay.
So
all right.
I removed him. Would you like him brought back in?
Absolutely.
Okay. If he continues to shift his camera,
I'm gonna redirect him right now. I'm gonna admonish him.
Thank you, Judge.
Thank you. And Miss Bullock, if you could just be ready to provide your answer. Okay. Mr. Booker, you need to have a seat. That you are in a court proceeding. You are not allowed to walk around. You wouldn't be allowed to walk around if you were in a court of law. Please keep your camera on at all times, and we need to see your entire face. Please don't play games with this court, Mr. Booker. We are not the military where you can apparently think you can play games by the documentation I'm seeing right now. So I don't want to hear your opinion, Mr. Booker. I'm not asking for any input from you. I'm giving you an admonishment and I'm warning you. I don't need a response. Just sit tight. Your attorney will do the work he needs to do. Leave your camera on. Do not move. Thank you. Miss Bullock, do you have an answer to Mr. Stateson's last question? He asked you if you had a specific date of your testimony that Mr. Booker had contacted you after May 27th of 2023.
Yes. I don't have the date, but I just have this with the police report incident. So if he wanted to find it, he could find it through this report, I believe.
Okay. Miss Bullock, was it in July or was it in June? Was it in August?
It was in July.
Okay. And you don't know the specific date?
No, Your Honor.
Okay, that's all right. That's your answer. Mr. Stateson, any other questions?
No further questions.
Okay. Next, any more direct examination, Ms. Flores, of this witness?
No, Your Honor.
Okay. Do you have another witness, Ms. Flores?
I do. If I can move Ms. Bullock and our advocate to the breakout room, and then I would like to call Major Timothy Shelby.
Okay. Miss Bullock, you and Kyle Pollock, our advocate in the courts, are going to be moved to a breakout room, and we will make contact with you when appropriate. Okay.
Yes,
Thank you. Can we bring in the next witness, please?
Yes,
Mr. Booker, I'm going to ask you one more time to show your entire face. Adjust your phone camera, please. Thank you. Can someone put Kyle in the breakout room with Ashley Bullock? Okay, we have Timothy Shelby on now. Mr. Shelby, welcome to County Court of Law 13. I'm Judge Rosie Speedlin Gonzalez. I do need to swear you in to have been called as a witness in this proceeding. Okay. Please, unnecessary testimony, and that you give each of the attorneys as much deference as you do the other. With that, Ms. Flores, the witness is yours.
Thank you, Your Honor. Let's see. Major Shelby, can you please tell me how you know the defendant, Justin Booker?
So I am Private Booker's company commander.
And are you aware of his arrest in regards to this alleged offense?
Yes, I am.
I am going to, oh, Your Honor, may I have permission to share my screen?
Yes.
I'm going to show you what has been marked as State's Exhibit B. I'm going to go a little bit out of order here. Can you see the letter in front of me on the screen?
Yes, I can.
Is this a letter that you wrote?
That is a letter that was prepared for me, and then I endorsed it. Yes. Okay,
thank you. Now, its subject line is unregistered weapon discovered in the barracks. It's dated July 21st of 23. Are these accurate descriptions for this document?
Yes, it is accurate.
And can you please tell us, the court, what exactly this memorandum is in regards to?
So this is in regards to on 17 July, we directed Private Booker to move into the barracks on post at Fort Eustis. And during this time, his platoon leader and his platoon sergeant, which is kind of like his first line leadership, got him into the barracks room, and then Private Booker voluntarily conducted a inventory. This is pretty standard practice of his personal belongings, high dollar value things of that nature. That way we know what's in the room, and then that way if there's any kind of loss or pilferage in that room, we know kind of what's in there. And during this inventory, it was discovered that there was a loaded firearm, and we found out it was unregistered. And then that's basically how that was discovered.
Where was the firearm located?
I'm trying to remember. I believe it was in some kind of like clothes hamper or bag with some sweatpants in it, and it was discovered by his leadership in that bag.
And just to be clear, even in the light of Private Booker's enlistment with the Army, this was not an authorized firearm. Is that correct?
Oh, that's absolutely correct. There's no firearms, personal firearms that are allowed in the barracks. And then even additional things such as knives and stuff is strictly regulated.
Did he share this room with anyone else?
No.
Is it possible it was anyone else's, or was it your belief this was in the possession of Private Booker?
It's definitely was in his possession because the room was empty when he moved in, so there's no reason that it would have belonged to anyone else.
Thank you. I'm now going to show you what's been marked as State's Exhibit A. Do you recognize this document?
Yes, I do.
And can you tell the court what it is?
It looks like it was for charges that happened towards the end of July, where he was arrested in Hampton, Virginia.
And can you tell us the date?
Let me find it. Looks like it is July 22nd, 2023.
This is after his arrest for the assault bodily injury he's currently charged with, correct?
Yes.
And I believe there were 2 documents on this. Can you tell us what the defendant was charged with? On this date?
Yes. So it was reckless driving, and then also evading. There's one other word: evading and eluding police with reckless driving.
All right. Thank you. No further questions.
Mr. Stateson, any questions of this witness?
Yes, Judge. I'm looking on my screen. I'm sorry. I see you. Sorry, Mr. Shelby. Do I call you Commander Shelby?
You could go Major Shelby or
Major.
Yep.
Major Shelby, the documents that you had looked at, did you help draft those, the regarding the eluding reckless driving? Did you help draft those documents?
No, those were charged. That was paperwork that was provided by Hampton or the county.
At what law enforcement agency is that? Do you know?
If I would, to my knowledge, it's the law enforcement in Hampton, Virginia.
But you were not present when Mr. Booker was arrested for those 2 alleged offenses, correct?
I was not present. However, his first line leadership were there to pick him up.
All right. No further questions.
Okay. Any more direct examination of this witness, Ms. Flores?
Yes, Your Honor, just briefly. Major Shelby, are you aware of any substance concerns with the defendant?
Yes, I am.
What's been brought to your attention regarding substance use with the defendant?
To my attention, it's been a positive urinalysis for methamphetamine, and then multiple self-reporting by Private Booker regarding repeated use of methamphetamine.
And when you say self-reporting, he's essentially admitting to use. Is that correct?
Correct.
No further questions, Your Honor.
Mr. Stateson, any further questions of Mr. Shelby?
Yes, Judge. Major Shelby, regarding those urinalysis tests, who ordered those?
So the first one, that is just part of a monthly, it's part of a regular thing that we do as a commander. And that was ordered, and then it's basically a random selection of 10 to 20% of our unit, of our organization, and then he was part of that.
So at this point, the feed was cut. I do apologize for that. I did go back to her channel later on in the day, and they are convening back some point next week. If I do get any updates, you will be the first to know. But I did feel that this was such a good clip of her lacing into that guy to show it to you as a main event. Have a good day, guys. I'll see you later.